Hello all of you. Welcome to ForumIAS. I am Kanishk Shekhar and today we'll try to understand Article 31A, 31B and 31C. So it all started with a case in 1950. The name of the case is Shankri Prasad case. Right to property was a fundamental right under Article 31. So this is 1950. The year is 1950 and right to property is a fundamental right. Under Part 3, that is your fundamental right. It's in Article 31. Now, Bihar Land Reform Act was passed. This law, 3 states passed laws, Bihar, MP and UP. The purpose of these acts as upheld by the governments of these states were to take over the land and distribute it to the poor. So these acts intended to bring what is called land reforms. What is land reform? In India, land reform has largely implied giving land to the landless poor. But the quantity of land being fixed, which means most of the land is owned by few landlords. So before distributing it to the poor, it has to be taken over by the government and then it will be distributed. But remember, under Article 31A, right to property is a fundamental right, which means landlords are not willing to depart from their land. So Shankri Prasad went to Patna High Court and challenged this law. That how can this government pass such a law which will take over my fundamental right under Article 31, that is right to property. Patna High Court invalidated the law, which means Patna High Court ruled in favor of Shankri Prasad. Which law it invalidated? This law. Bihar Land Reform Act was invalidated, which means turned down by the Patna High Court, and Shankri Prasad won the case. So who lost? The government lost. Who won? A private citizen, a landlord won. Now, what is the option before any party? Here, the party which has been defeated is the government. So what is the option before a party which loses case in a high court? The answer is very obvious. You all know it, that it will challenge the judgment in Supreme Court. But the prevailing wisdom was not in favor of challenging this judgment in Supreme Court. The Constituent Assembly, using the powers it had under Article 379, passed the First Amendment. Now, today if you try to find this article in the bare act, you will not find it, because Article 379 said, until the first parliament is there, the Constituent Assembly will discharge the functions of the parliament. I mean, who else? Unless we have the first Lok Sabha and the parliament is elected, Constituent Assembly will discharge the functions of the parliament. And one of the several functions of parliament is to amend the constitution. So here comes the First Amendment. And this First Amendment did 2 things. It inserted Article 31A and 31B into the Indian Constitution. 31A insulated land reforms from judicial review, and 31B created 9th schedule. Article 13 provides for judicial review, which means any law passed by any legislature, be it Parliament of India or a state legislature, it can be challenged in the courts, Supreme Court, Article 13, and same powers high courts have under Article 226, which means any law passed by any legislature can be challenged in the court and court can review that law. But 31A says that judicial review will not happen. Judicial review cannot happen. Further, it also, first thing it did, First Amendment did was to bring 31A. In fact, First Amendment introduced 4 changes, but here we are concerned with only 2, 31A and 31B. 31A insulated land reforms from judicial review. 31B created 9th schedule. 9th schedule is also called the black hole of the Constitution. What happens in black hole? You have learned this in your high school physics, that nothing can come out of black hole, not even light. The gravitational pull is so strong. So if any statute is another word for law, any law or statute, if it is placed under the 9th schedule, judiciary cannot take it out and review it. So double protection is being granted to land reforms. Insulated land reform from judicial review, and any law which is placed in the 9th schedule, the review by judiciary cannot happen. These were the 2 things that First Amendment did. Now, of course, this First Amendment was challenged by Shankari Prasad in Supreme Court, but Supreme Court, remember, Nehruvian era is also referred as era of passive judiciary, because Supreme Court was not aware of its own power. Not to blame anyone, but newly independent country, the institutions take time to discover their own power. As and when the democracy progresses, the institutions become strong. So Supreme Court itself took time. Article 13, as I said, provides for judicial review. Now, this amendment was challenged in Supreme Court. Shankari Prasad said that First Amendment goes against my fundamental right, that is Article 31. So please review it, and in all probability, please cancel it. Supreme Court was not willing to do that. Supreme Court was not willing to touch an amendment. Remember, this is an amendment. Under Clause 2, under Article 13, Clause 2, any post-independent law can be reviewed by judiciary. Article 13, Clause 1 is for pre-independent laws. For example, IPC. Anyways, we have Bharat Nyaya Samhita. But Contract Act 1872, IPC is written by Lord Macaulay, then Evidence Act, then Indian Police Act of 1861. These are laws which came before the Constitution. All these laws can be reviewed by Supreme Court under Article 13(1). As I said, it applies to pre-constitutional laws, which means those laws which came before the Constitution came. But 13(2) applies to post-constitutional laws. Post-constitutional laws, which means those laws which have been enacted after the Constitution was enacted. For example, First Amendment. First Amendment came after the Constitution, so it will be challenged under Article 13, Clause 2. But Supreme Court was developing cold feet. It said that the word law in Article 13, Clause 2, any law can be challenged, but this law does not mean amendment. So court is not willing to review this amendment by saying, I can only review ordinary statutes. I cannot review constitutional amendments. This was Supreme Court in India in Shankari Prasad case. So Article 31A and 31B, which came through the First Amendment, 31A insulated land reforms from judicial review, 31B created 9th schedule, which is also called the black hole of the Constitution. Any statute placed in 9th schedule cannot be taken out and reviewed by judiciary. These 2 provisions were protected. These 2 provisions were not cancelled by the Supreme Court. Now, regarding 31C, one more case happened. Now, this case is not there in, this was a very late development, R.C. Cooper case, also called bank nationalization case. So R.C. Cooper, member of Swatanta Party. Swatanta Party was one of the few parties which believed in free market economics way back in socialist India, which means they were way ahead of their times. Minu Masani, then C. Rajgopalachari, they were the members of Swatanta Party along with R.C. Cooper. Now, 14 banks were nationalized by Indira Gandhi government. So R.C. Cooper went to the Supreme Court and said that these banks should not be nationalized because these are private properties. How can government nationalize these banks? What will happen to the shareholders? He was one of the shareholder of one of those banks. Now, 10 is to 1 judgment came, and 11 judges bench started to adjudicate this case, like whether the government of the day had the power to nationalize these 14 banks. 10 is to 1 judgment favored Cooper, which means he won the case. He won the case in Supreme Court of India. Only one judge, a lone dissenting voice, favored the government. 10 of them favored R.C. Cooper. Now, government did not like it. This judgment was not liked. So in comes the 25th Amendment. And this 25th Amendment inserted Article 31C. Now what this 31C says? 31C says that any law which implements provisions of Article 39 subclause B and 39 subclause C shall not be challenged. Shall not be challenged on grounds that they violate Article 14, Article 19 and Article 31. Remember, this case is 1969, which means right to property is still a fundamental right under Article 31. So 31C says that any law which implements the provisions of 39B and C. Now, what are 39B and C? What are the provisions? These are Part 4, DPSP, and these two articles have been labeled as classical socialist provisions by no less than Granville-Austin. Granville-Austin was an American jurist, but he was also an expert on Indian Constitution. Wonderful books he has authored, Cornerstone of the Nation, so on and so forth. So Granville-Austin says that these two articles, these are classical socialist articles, which means what are the provisions of 39B and C? That concentration of wealth should not happen. Material resources should not be in the hands of few at the cost of utilitarian, which means let common people have access to resources. The concentration of wealth and resources should not happen. That is the essence of 39B and C, and that is what makes Granville-Austin say that these two articles are classical socialist, which means they are for utilitarian purpose. It aims to bring redistributive justice, equity to the people, give resources to the people instead of confining it in the hands of few. Now the government is providing it a constitutional backing. That 31C says any law, which means if banks are nationalized, then few shareholders cannot come and say that why banks have been nationalized, I am losing my equity, because common people will get access to those banks. So 31C constitutionalized, it gave constitutional backing to any law which is to be implemented in order to bring 39B and C. And it will not be challenged. Those laws will not be challenged on the grounds that they are violative of certain articles, that is, certain articles 14, 19 and 31 violative of fundamental rights. So this was Article 31C. Now recently this year, April 2024, Supreme Court was hearing another case regarding the validity of Article 31 itself, 31C itself. So is Article 31C still valid? This question was raised in Supreme Court in the month of April 2024. Why this question was raised? Because the moment 25th Amendment is 1971, provided for 31C. And we have already seen what 31C is capable of. It will ensure that any law that implements provisions of 39B and 39C cannot be challenged on the grounds that they are violative of 14, 19 and 31, which means Part 4 will score over Part 3. DPSPs will have greater weightage than fundamental rights as per these articles. 25th Amendment was challenged in Keshwanand Bharti case, the landmark case. I am sure most of you have heard about it. The basic structure case. It was challenged. Now, Supreme Court upheld 25th Amendment except for the provisions that restricted judicial review. So court बता रहा है कि you keep doing all the amendments. We are okay with it. But don't tell us that we cannot review your amendments. So you bring the amendment, you implement DPSPs at the cost of fundamental right, but it is our task to review it. So any provision of any amendment that restricts judicial review will not stand judicial scrutiny. So this amendment is fine, but don't tell us that we cannot review your amendments. So this is 25th Amendment, which was partially struck down in Supreme Court in this Keshwanand Bharti case. Now further 46th Amendment was passed. This is 1976. 46th Amendment was passed, and now what happened in here? Here the court said that, here the law said that any provision which implements DPSPs, provision as in any legal provision, any law which implements DPSP cannot be challenged in court. So this implies that any provision of DPSP which has been implemented cannot be challenged. This was the 42nd Amendment 1976. 25th Amendment said that 31C, if it implements provision of 39B and 39C, then do not say that it violates Article 14, Article 19 and Article 31. But 42nd Amendment is saying not only 39B and 39C, any of the DPSP means Article 36 to Article 51. Entire Part 4, if these provisions are implemented, then it should not be called in a court. It should not be questioned in a court. You cannot say that it is violative of fundamental rights. Now, 42nd Amendment was in Minerva Mill case partially struck down. Parts of 42nd Amendment. Which part? That any provision of DPSP if implemented, cannot be challenged on account of violation of fundamental rights. So this particular portion was struck down by the court in Minerva mill case. Now this year, in April 2024, this question came back in Supreme Court. What was the question? The petitioners asked that is 31C still valid? Are the provisions of 31C still applicable? Which means, can government still pass a law which goes against provisions of Part 3? And government will say, no, we are implementing provisions of DPSP, so we don't care about fundamental rights. Or has 31C ceased to exist because there are two judgments, one which struck down portions of 25th Amendment, the other which struck down positions of 42nd Amendment. So is 31C still applicable? Is Article 31C still alive? Now there are several permutations and combinations that may emerge. Post Keshwanand Bharti, will it go back to its original position, what it was before the Keshwanand Bharti judgment came, or it's completely wiped out? Only the Supreme Court will tell us. The judgment is still pending. As and when judgment comes, we shall meet again. Thank you.
Join ForumIAS Academy, trusted by thousands of toppers since last 12 years, including IAS Rank 1 Anudeep Durishetty, Shruti Sharma, and Ishita Kishore.